Hello everyone, welcome to the Canada Truth channel where Canada, the illusion of freedom and system of control is exposed. Today's video, my public summary of evidentiary brief in my constitutional challenge case that I've been collaborating on for a long time. I cannot release all of the case and the entire brief and body of evidence before I file in the Federal Court of Canada on behalf of myself and the people of Alberta. But I can't do this alone. I need your help, especially the people that support Alberta independence, be it Alberta becoming the 51st state or Alberta becoming a sovereign nation, which we have been since December 11th, 1931, which is what this case is all about. Despite everything else with the BNA 1867 and everything that happened during and after that, this is how we need to proceed. And if you don't support Alberta independence and separation, as a Canadian in the other provinces and territories, you should want to ensure that Canada is governed by the rule of law and not the color of law. Okay, so the whole case I can't release. It's almost completely finished and ready to go. But I can provide this public summary of the evidentiary brief that's part of the constitutional challenge. I hope that makes sense. So here is our summary overview. This summary provides a publicly available overview of a constitutional legal challenge to be filed in the Federal Court of Canada by the plaintiffs, me and the people of Alberta, and the people of Canada for that matter. The case calls into question the lawful authority of the Federal Executive Government of Canada, the validity of the 1982 Constitution Act, and the use of unelected executive powers derived from the British Crown. The challenge is based on historical documents, federal orders, statutes, and constitutional law principles that demonstrate a consistent pattern of unilateral executive action by the federal government since 1931, absent democratic ratification or provincial agreement. Some of our legal questions in this case will be formulated around these questions. Some of them, not all of them. Does the federal government have lawful constitutional authority to act as a sovereign entity after 1931? Are actions taken by the Governor General under the 1947 Letters Patent legally valid? Was the 1982 Constitution Act lawfully enacted and proclaimed? Context. In 1931, the Statute of Westminster granted Canada and the provinces full legislative independence from the United Kingdom. From that point forward, no UK law could be applied in Canada unless requested and consented to by Canada itself. However, This authority was assumed solely by the federal executive government, Prime Minister Mackenzie King and cabinet, and not by the provinces or the people. Between 1931 and 1982, Canada, the federal executive government of Canada, continued to request British amendments to its constitution without any national referendum or provincial ratification. The 1982 Constitution Act was proclaimed by the Governor General acting under the powers granted in the 1947 Letters Patent, an executive instrument issued by King George VI without following any procedural requirements, and the parliamentary or constitutional approval. Some of our exhibits will be the 1867 BNA, which established Canada as a British Dominion and vested authority in the Crown through the Governor General. The Statute of Westminster, 1931, ended British legislative supremacy over Canada and the provinces. The provinces were no longer British colonies. 1949, federal-only amendment to the BNA. The enactment of BNA number 2, 1949. The federal government alone asked the UK to amend the British North America Act without any provincial input, public notification, and consent. They did it on their own to stay in power. The 1947 Letters Patent unilaterally expanded the powers of the Governor General under royal prerogative, bypassing authority, procedure, the provinces, and Parliament. The 1982 Constitution Proclamation issued by the Governor General under the authority of the same 1947 Letters Patent, the ones without provincial consensus or constitutional reform procedures. Yes, these Letters Patent are still the Letters Patent the Governor General is acting under today. Why this matters. Canadians have never voted to approve a constitution. We have never had a constitution by the people for the people. We have had the British North America Act, now known as the Constitution Act 1867, which created the United British Colony, the Dominion of Canada, and the executive government of that United British Colony through the Governor General on behalf of Queen Victoria. That's it. Quebec never ratified the 1982 Constitution. Key powers of government were transformed by executive orders and letters from the Crown rather than democratic consent or constitutional convention. They just did it by themselves, stay in power, keep the money rolling in. This challenge calls for transparency, democratic accountability, and lawful constitutional process for the provinces and territories, and then for Canada. Join the conversation. Canadians deserve to know the full history of their Constitution. Whether you support Alberta independence through separation or you don't. If you like the government or you don't. You have the right to know the truth about Canada and its government. Period. Not only that, you have the responsibility to know in order for you to make informed decisions. This case is about restoring the rule of law, accountability, and the fundamental legitimacy of the provinces and Canada's government. These facts in law are especially important considering the ongoing debate regarding Alberta separation. The foundation starts with each province and territory. This must be done by the people of the provinces and territories through public education, engagement, constitutional conventions, and then an agreement by the provinces to federally unite under a ratified constitution by the people for the people. That's what this is all about. My sinister motivation in this pursuit of the rule of law is I want an Alberta and a Canada that I can believe in. One with a constitution written by the people for the people. As sinister as that may seem, that's my motivation. And I hope it is yours as well. And once again, I can't do this by myself. And to expect the federal government and the provinces and the courts who are appointed by the government to act honorably when they've historically acted dishonorably, it's foolish to put everything in the system to work against the system, to help correct the system. The system was designed by them, the rules were written by them, and we have to understand that. And Alberta separation means the demise of the system. So, no matter how the courts rule on this case and any other cases, the courts are courts of public record. So this information will be public. These are undeniable facts in law, and the court will be forced to recognize them. They may rule on the continuity of government or the de facto doctrine or some other provision, but this information, these facts in law, will make it to the public, and the media is going to be forced to cover it as well. In previous videos, I have shown you all of this information, and here we go. Why in 1931 Canada, the federal government of Canada, chose not to exercise its full autonomy as provided for under the Statute of Westminster. We have covered the Statute of Westminster as well, and the sections pertaining to Canada. We have covered the letters patent from 1947 that were not signed by the King, did not have the Great Seal, were signed by His Majesty's command by Mackenzie King, the Prime Minister of Canada. I have covered the British North America Act number 2, where the Senate and the House of Commons of Canada in Parliament assembled have submitted an address to His Majesty, praying that His Majesty may graciously be pleased to cause a measure to be laid before the Parliament of the United Kingdom for the enactment of the provisions hereinafter set forth. The federal government, through an order in council, made a plead praying to His Majesty to enact the British North America Act number 2, 1949, so they could stay in power. And just like the original British North America Act, the British North America Act number 2, 1949 is legislation of the UK government. It's not a constitution by the people for the people of Canada. So please use the links I provide, educate yourselves, share this information, and especially in Alberta, when you're talking about the government in general, whether you're talking about Alberta independence, please use this information because no one will talk about it. These are facts in law and no one wants to touch them. They are undeniable. So when the federal government and the other provinces and the courts likely act dishonorably, this is going to come out in public record. And who knows, maybe the courts will have a conscience and rule for the truth and the people. But either way, this will come out publicly. Now, follow the links I provide. Please also go to the Myth is Canada YouTube channel, also the Myth is Canada website for more information. The Myth is Canada has been working on Canada the Illusion, this documentary, for a long, long time. It's finally been released. It is fantastic. It gives you the historical truth and history about Canada that we were never taught. It's a fantastically written and produced documentary. It's well worth your time to educate yourselves, and it gives you a great broad overview of the constitutional limbo that the people of Canada find ourselves in, which is the root cause of all these problems and issues ongoing. So subscribe, watch and share Canada the Illusion. Come back to Canada Truth Channel for more information, and I will get these documents downloadable hopefully tomorrow. It's been a very long day and a long weekend, so stay tuned. Thank you for watching. Please share this information.